As soon as I get the files, I'll do that one from Wayne County. The Anton Brooks. You all have a DeAnton Brooks? Let's see.
Yeah, then it could have happened to anybody.
DeAnton Brooks, how can I help you?
I had a court appointment today. Court appointment today.
For you have an arraignment?
Yes, ma'am. It was supposed to be. I couldn't find the time, but it was supposed to be for. It was supposed to be to close one of my cases for an arraignment on weapons charge.
Okay, hold on a second. Let me have them look at the list.
Okay.
And your last name is Brooks?
Yes.
Okay. Do you have your own attorney or are you going to use a court-appointed attorney?
I was using a court-appointed attorney.
Okay, let me get one of them here so that we can put you in a breakout room to speak to him. You don't see a Brooks as a walk-in on your?
No, I don't.
Okay. Did they tell you courtroom 134?
They never told me because I had talked to you on Wednesday, June 28th, and I just wrote the date down for July 5th.
Oh, that's probably not an arraignment. That's probably your probable cause conference. That's what I'm thinking. What judge did it say?
On the first judge was Judge People.
No, we don't have a Judge Peoples. Not at 36th District.
Let's say Cheryl.
Deanton, Deanton. So listen, we each need one. Thank you. So when you said you were for arraignment on the 28th of June?
Yes, and I spoke with.
Go ahead.
Oh no, and I was on there with you, and I just remember just this date I wrote down, July 5th.
Okay, that's probably a probable cause conference. It's probably not scheduled to be here today. Do you have the case number?
Yes, I do. It is 22055.
Scheduled for review.
53 what? Oh, I lost you.
I'm sorry. I started. 220.
Yes.
555 3101.
Okay, let me see where you're supposed to be.
Judge Robbins.
He's supposed to be in front of Judge Robbins.
Yes.
Okay, you're in the wrong courtroom. And I don't
okay.
know Judge Robbins' courtroom number, so hold on.
Yes, Kevin Robbins.
Yes.
440, Your Honor.
440.
Yes, ma'am.
Okay, so you should be zooming into 360,
Mhm.
360 again.
No, it's 360-440.
I don't think everything that ends in a zero doesn't go the same way. Just like 220 and 540, it doesn't go the same way as the others. Should be 360, 440. Huh?
0.
That's not it. It's three
Okay,
six zero,
okay.
440, 0000.
Okay, well, they've told me that any courtroom that ends in zero does not go that way. Just like 220, that courtroom does not go that way. And neither does 540. Those do not come in that way.
Then that means they can have them wrong.
So they're not done that way, is what they told us. And I know for a fact 220 and 540 don't do it this way.
Can I ask you this? Can you ask him if he got a notice?
I think he was a walk-in before, but a Zoom in before. Did you get some kind of notice in the mail, Mr. Brooks?
Yes, the notice, only the first time I got the notice, which was for June 28th. But I
For
didn't get a
June
notice.
28th?
Yes, I didn't get a notice for it today.
Okay. What- Then because I'm told that maybe I'm wrong on that particular courtroom, let me give you two different Zoom IDs for you
Okay,
to
I'm gonna
try,
get
but you're in the wrong courtroom right now.
okay, let me get a pen.
Because they need to tell everybody that.
Where are you going?
Okay. I had to get a pen.
Okay.
Okay.
Don't do what you said. It says invalid.
Don't do which one?
What we
We
said.
are.
Okay,
Invalid.
okay.
Okay, I'm ready.
You ready?
Yes.
360,
Okay.
360 again,
Okay.
0440.
Okay.
Okay, so
Thank
that's where you
you.
should log in, okay? All right,
Okay. Thank you.
all right.
So that's, what's the rule behind that?
When the courtroom ends in a zero, 220, 340, well, any of them end in zero, you do 360, 360 again, 0, whatever the courtroom number is. Mhm. Okay. These are the ladies. That's your man with 3. This is the walk-in. Okay. At all. Yeah. This one that's at Wayne County Jail. Oh, okay. That's the person. Oh, that was you. Okay. Both of these. Hold on. Wayne County Jail. Not the one that says, not you, the other one. I think the Wayne County Jail that has Brianna Allen. Is that who you have? Nope, apparently not. So Wayne County Jail, who do you have?
Both those mine?
What's your name, sir?
Truitt, JT Truitt.
Pruitt?
JT Truitt, TRUIT.
Let's see.
I got it. It's mine.
Okay, but it's, okay.
Yeah, only 4 or 5. You might as well let me start first then.
Well, we're gonna do the Wayne County Jail
Oh, okay,
first.
I'm sorry. Oh,
Just,
that is right.
just hold on.
Okay.
Both of you, hold on. And Shola, that's the walk-in. So that I know which ones to put in the computer. That's mine. And then I'll do this. Okay, Mike Sholot. Step up, please. Case number 230-44426, people of the state of Michigan versus Mike Raymond Sholot. Counsel. Would you file an appearance? Okay. Yeah, then let me write down your P number. Say your P number again.
55436.
And what was your last name? Okay. All right, sir, what's your name for the record, please?
Mike Raymond.
Okay. Counsel, as to the arraignment.
Waive the readings and units for pre-trial.
Okay, court's gonna enter a not guilty plea on your behalf. Is there anything as to bond?
He went to prison during the time that this occurred. He didn't know the warrant was issued. There is another one as well, but that's for the same reason, from probation. There is $972 for the previous. We're just gonna pay that today and get it. In council, and we're gonna try to clear this up in 2 months. He gets off of parole. Trying to clean up his life.
Yes, sir. All right, sir, you're not to have any contact with any casinos at all during the pendency of this matter. We have a pretrial date of August 24th, 2023, 8:30 a.m., 36th District Court in front of Judge Bryant. Court is going to set your bond, sir, in the amount of $1,000. This is going to be a personal bond. Okay, you can have a seat and wait for your paperwork. This is yours. Go ahead. No, she's on the screen and the gentleman is on the screen. And this one will be next. I don't know which screen.
Lady, and this is the gentleman through it. Okay. Okay. All set? On the other. Okay. Calling case number 220-55874. People versus Megan Pope, AKA Megan Nicole Grogan. Appearances, please.
Yes, Your Honor, James Walker, needs to have
Thanks, Judge. Good morning. Steve Vincent for the people, B71917.
Okay. Your Honor, when reading and request for personal bond.
Okay, we're gonna get bond argument in a second, but as for now, you're waiving the formal reading complaint. Okay, I'll enter, not guilty plea will be entered on your client's behalf. Give me 1 second here. Okay, argument as to bond. Oh, I'm sorry. Ma'am, state your name for the record.
Megan Nicole Rogan.
Okay, my apologies. Argument as to bond.
This is, it's non-assaultive in nature. I'm sure Your Honor saw that this is an offense that took place in the very last day of 2022. Your Honor, the people couldn't find any incidents involving the defendant following the one before the court today. We wouldn't object to a personal bond. However, we would be asking Judge for a no contact, at least through the pendency of this case with the complainant, as well as where the incident took place, which is that Livernois Oil Express.
You said no contact with the complainant and the Livernois Express?
Correct. But with that being said, we wouldn't object to the personal bond.
Are there any pending cases to your knowledge?
No, Your Honor, it's the reason why we wouldn't object to.
Okay.
There's been nothing since this incident.
Okay. Counsel, any objection to a personal bond?
I would everything else.
Okay.
All I felt is a lifelong. She's not going anywhere. Well, clean this up.
Is she employed?
No, not that she is. But I'll clean it up.
Okay.
I can go on the other one.
Okay. The court will adopt the recommendation of both parties and set a personal bond. Ms. Did you go by Ms. Grogan or Ms. Pope?
Yeah.
Ms. Grogan, okay.
Prison boy.
I'm sorry?
Is Grogan?
Grogan, okay.
Yeah.
My apologies, ma'am. While this case is pending, you're not to have any contact with the complaining witness, Norman Aldred. That means no verbal, written, or any communication, email, or through social media. Do you understand that? And you're not to go to the location of 4950 Livernois in the city of Detroit. Do you understand that?
I do.
Okay, one moment.
Right down here. Like, no contact with a particular person is here. No contact with a particular place is here.
Okay, all right, thank you. Okay, bear with me one moment. Okay, your next court dates, Ms. Rogan, are July 12th, probable cause conference in front of Judge Sabri. And on July 18th, you have a right to a preliminary examination in front of Judge Sabri. I've outlined the, I'm sorry?
July 12th?
July 12th is a probable cause conference in front of Judge Sabri. And July 18th, you have a right to a preliminary examination in front of Judge Sabri. I'm going to give you a personal bond. The court's going to adopt the recommendation of the people and your attorney and give you a $5,000 personal bond with the conditions I just outlined for you. No contact with Norman Aldred and no contact with 4950 Livernois. Do you have any questions regarding your court dates or your bond conditions?
I don't, no, I don't, Your Honor.
Okay, thank you. Anything else from counsel? All right, thank you.
But somebody, I think this is NDOC, the guy that has three.
Oh,
So we'll get those in a minute. Let's do them.
okay.
I'll just let them in so that they know we're not. Ask them his name.
Sir, state your name for the record. You got someone with the hands folded.
Tell us so we know.
Aries Evans.
Okay.
You don't have to do it next. I just want to make sure. We
All right.
When you're done with this, just come over the door and get their attention and control center, all right?
Okay.
He hasn't been interviewed. Mr. Evans, have you spoken with an attorney yet?
No, ma'am.
Okay, just stand by.
True. Okay. Well, I don't have a defense attorney. That's here, right?
And I always go to a sign manually. If not, you'll get put in the breakout room. So I believe.
Oh, you made that mistake?
Yeah. And so once the defense, once the attorney logs in here, we'll put them in the breakout room. But you can go ahead.
Okay. All right. Mr. Gregory, we're good?
Yes, Your Honor, we should be having to lay down in the interview.
Okay. All right, calling case number. 1 second. Oh,
So
fair
that
enough.
way we have the right file.
Okay.
I mean, we know who he is,
Right.
but just get in the habit of that.
Okay.
Okay, so first we have to let them in. That's true.
All right.
Then we're gonna put,
Ms. Reasonova, we're gonna put you in the waiting room with Mr. Evans, I think it is.
In the breakout room?
That's what I meant to say.
okay.
So,
Yep, That's what he is. That's her right here. And then we open the room. And they will, if something pops up for them to accept that.
okay.
And so now they're in the breakout.
Okay.
Close that out and you can go ahead.
All right. Sir, state your name for the record.
JT Truitt,
Is it James P. Truitt? Is that your name?
JT Truitt.
J.T. Truitt?
Yes,
James Truitt, okay.
You said JT. so-
no, I'm not James.
I have, you're not James Truitt?
No, I'm JT Truitt, Junior.
What is your date of birth, sir?
April 8th, 1953.
Okay, the same date of birth.
Sir, have you ever gone by the name James?
Yeah, when I was in grade school.
Okay.
All right. All right, Mr. Truitt, calling case number 120588944, people of the state of Michigan versus James P. Truitt, also known as J. Truitt. Appearances, please.
Thanks, Vince. Good morning. Steve Benson for the people.
Good morning, Your Honor. Austin Gregory, PA 5193 on behalf of Mr. Truitt. And can you explain this, grateful reading of the information? That's what's in your negative plan.
The court will order a not guilty plea on Mr. Truitt's behalf. It looks like these are allegations that are over 10 years old. Argument as to bond.
That's absolutely correct. This happened roughly about 10 years or 12 years and a month ago. Very significant, and just based on everything that appears in the investigative report, there is a high likelihood of conviction. However, Your Honor, looking at how old this case is, also being non-assaulted, as well as the fact that there aren't any convictions following this incident, the people aren't going to be objecting to a personal bond if the court so inclined.
Your Honor, we do ask for a personal bond.
Is your client employed now?
He is employed, Your Honor, as a school bus driver.
Okay. The court adopting the recommendation of both the people and defense counsel will set a personal bond in this matter. Give me one moment.
It's not much, did you? Not that I give her
All right, just
whatever bond.
okay. All right.
Or you tell them not to be involved in any real property transactions. What you can say.
Okay.
Tell them.
Just tell them I want to put it. I can't put it.
You could put it on there if you want. It's just not much you can do about it.
It's been 11 years. He's done anything since. All right, Mr. Truitt.
Yes.
The court's going to adopt, as I stated before, the court's going to adopt the recommendation of the people and your attorney and set this matter for a $5,000 personal bond. While this case is pending, I would encourage you not to purchase any property. One second here.
Your Honor, if I may.
Sure.
The concerns that the people had in this particular matter were as a direct result of how the defendant ended up thinking that he could acquire property in the city of Detroit. If I could just point out to Your Honor on, I believe it's the second to last page of the investigative report, allegedly the defendant had heard, and then he subsequently followed what he had heard with his own action, that abandoned properties in the city of Detroit that were vacant or had taxes that were owed against them and nobody lived in them, that he could just go downtown and do a quick claim deed, and then the city would sign it over to that individual and he would acquire that property. Your Honor, now this is 12 plus years old. That was the concern that the people had in how the defendant thought he could acquire property in the city of Detroit. So maybe Your Honor could just address that. However, with that being said, we still wouldn't object to the personal bond.
Okay. I think by no purchasing any property under those, well, one moment. Mr. Truitt, if you're going to purchase any property in the city of Detroit, just do it through proper means, through a real estate agent, contact the previous owner, and do it through a land contract or any appropriate contract, purchasing it from an owner of the property, not assuming that it's just because it's abandoned, you can go ahead and do what Mr. Vincent claims you can do. Is that understood?
Yes, sir.
Okay. And Mr. Gregory, anything you want to add with respect to that?
Just Your Honor, that he's been in jail for 5 days, so.
Okay.
He has not received his medicine.
All right, the personal bond should take care of that. The $5,000 personal bond with those following conditions. Is there anything else from either council in this matter?
Judge, I just believe we need, and maybe I'm remiss. I don't know if we got the PCC or examination.
Oh, I'm sorry. That's why I asked. Okay. All right, Mr. Truitt, your probable cause conference date is July 12th in front of Judge Sabri, and your right to preliminary examination on July 18th. Do you have any questions regarding your bond conditions or court dates?
No, I do not.
Okay. Anything else from council?
No, thank you.
All right. Thank you.
Thank you.
Okay.
Yeah. The person.
They're not ready yet.
Okay. All right.
No.
I'm not sure if he was
Jail, right? Go ahead.
To DDC.
All right, that concludes your arraignment, sir.
Okay. I'll be released off that $5,000 personal. Will that be today?
I can't, well, you have a personal bond. I don't know what else you might have going on, but for this case, you have a
Okay.
personal bond.
Okay.
All right. Usually DDC calls into us.
Yeah, they don't call.
Morning, DDC. How you doing? Okay, so I'm gonna do some cases and Magistrate Burton is gonna do some cases. So can you bring mine out first? That will be number 5, Carter, number 6, Higginbotham, number 7, McKenzie, number 14, Delvon, number 15, Thomas.
Copy that.
Thank you.
What's your name? Touch it. Touch it. Navarro's not down here. Is that Navarro?
Navarro, yeah.
Not down here.
What's your name, sir?
Orlando Carter.
Okay. All right, Mr. Carter, you also have some traffic matters that need to be addressed. These are tickets where you previously failed to appear in court. You're going to be given a personal bond on these matters. But you must return to court by Zoom for these tickets. Your pretrial date is August 1st, 2023, 8:30 a.m., 36th District Court in front of Judge Jones. When you appear in court, you have a right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford an attorney, one will be provided for you at public expense. These are misdemeanors with a penalty of 93 days and or $500 fine. Do you understand that, sir? This ticket SP 1015272 from October 11, 2019, driving while license not valid, no insurance misdemeanor. SP 1346718 from May 2nd, 2022, driver's license never acquired, no insurance misdemeanor. SP 1369501 from July 20th, 2022, failed to display a valid operator's license. SP 1382724 from September 29th, 2022, driving while license not valid, no insurance misdemeanor. SX 3966095 from December 15th, 2021, no operator's license on person.
Need Brianna Allen vote. Allen. Sir.
Just a second, sir. We'll get to your other matter. Okay, now you also have case number 220599938, people of the state of Michigan versus Charles Carter. Counsel.
Right, I formally read in front of the P23-157 on behalf of people, Your Honor.
Hey, good morning, Your Honor. Officer Gregory, P85193, on behalf of Mr. Carter, who's been made aware of constitutional rights away from reading.
Okay, court's gonna set aside the warrant. This is a capious matter. And a plea of not guilty on your behalf. Sir, when you failed to appear in court on November 15th, 2022, the court, the judge set a capious bond of $1,000. However, the judge did make that a personal bond. Anything from counsel?
And we have no objection to,
No, Your Honor.
Okay, and so, sir, the court has no authority to change this bond, and your counsel has not asked for it to be changed. Court's going to continue the $1,000 personal bond. You are not to purchase or possess any firearms or any other weapons during the pendency of this matter. Do you understand that, sir?
Yes.
Sir, you absolutely must return to court. You have a probable cause date of July 12th, 2023. Is this going directly to Judge Sabri? Or would it go back to Judge Robbins first? Yep. Okay. All right, probable cause date of July 12th, preliminary exam date of July 18th, 2023, 8:30 a.m., 36th District Court in front of Judge Sabri. You must appear, sir. Step away from the camera.
I'm sorry, Judge. What other numbers you had? You got Bless, you got Carter, Higginbotham, all those? 5, 6.
5, 6, 7, 14, and 15.
Gotcha. Oh, right here, man.
All right, right here.
Stand up. Say your name.
What's your name?
How you doing? I'm Willie Higginbotham.
All right. This. All right, Mr. Higginbotham, you have some tickets that need to be addressed. These are tickets where you previously failed to appear in court. You're going to be given a personal bond on these matters, but you must return to court by Zoom on these tickets. Do you understand that, sir?
Yes, ma'am.
These are misdemeanors with a penalty of 93 days and or $500 fine. You have a pretrial date of August 2nd, 2023, 8:30 a.m., 36th District Court in front of Judge Millhouse. When you appear in court, you have a right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford an attorney, one will be provided for you at public expense. Do you understand your rights, sir?
Yes, I understand you.
Okay. This is ticket U 598-31021 from May 16th, 2021, interfering with the city employee. U 457-96918 from June 14th, 2018. Trespassing. U 475-70618 from October 29th, 2018, violation of city controlled substance code. Now, we also have case number 1044717, people of the state of Michigan versus Willie Matt Higginbotham. Counsel.
Morning, Samuel A. Ragnan, P23-137 on behalf of the people.
Down there, please report. Good morning to the break, 57156 on behalf of Willie Higginbotham, who is here on Zoom, ready for represent.
Okay, court's going to enter a not guilty plea on your behalf with recall the capias. This is a capias matter. Anything, Esteban? Sir, well, first of all, sir, when you failed to appear in court for your pretrial hearing, the judge set your bond in the amount of $500, 10%. Anything, counsel? What? Okay, well, sir, the judge set your bond in the amount of $500, 10%. You are absolutely not to have any contact with any GDOT buses during the pendency of this matter. Do you understand that?
Yes, ma'am. Yes, ma'am.
Your client employed, Mr. Reagan?
Judge, he is unfortunately not at this particular time. He's a city judge, but he's not working right now.
This matter dates back to May of 2021. Court is going to set your bond, sir, because Judge Bryant has given this court the permission to change her bond in the amount of $500 personal. You'll have a $500 personal bond. We have a pretrial date of August 25th, 2023, 8:30 a.m., 36th District Court in front of Judge Bryant.
Was that judge? I'm sorry.
August 25th.
Thank you, Judge.
All right, so you may step away from the camera.
Okay, so, come on, let's go. Come on, bro. Step on the black line, say your name.
Like, I face the camera, say it for that.
Philip McKenzie.
All right, Mr. McKenzie. We have traffic matters which need to be addressed. These are tickets where you previously failed to appear in court. Court is going to set a personal bond on each of these matters, but you must return to court by Zoom on these tickets. Do you understand that, sir?
Yes.
All right, these are misdemeanors. Okay. These are misdemeanors with a penalty of 93 days and or $500 fine. You have a pretrial date of August 3rd, 2023, 8:30 a.m., 36th District Court in front of Judge Wagner. When you appear in court, you have a right to remain silent. Anything you say can and will be used against you in a court of law. You have a right to an attorney. If you cannot afford an attorney, one will be provided for you at public expense. Do you understand that, sir?
Yes.
Okay. This is ticket SP 1344946 from May 10th, 2022. Driving while license suspended. SP 1344947 from also from May 10th, 2022. Driving while license suspended. SP 1344948. Okay, all of these are the same date at the same time and same location. So some of these are going to be dismissed. This one is SP 1383905 from September 26, 2022. Count 1, open alcohol in a motor vehicle. Count 2, driving with revoked license. You also have case number 190464999, people of the state of Michigan versus Philip McKenzie. Counsel.
T23-157 on behalf of people.
Reagan, on behalf of Mr. Philip McKenzie.
All right. This is a capious matter. So, was there anything else?
Somebody thought his brother was using his name on this particular case. I thought this matter got cleared up. Bond is $10.
First, the court's going to enter a not guilty plea. I assume that's what you wanted to have happen. We did not, but the court will do that and recall all warrants and capiouses. Is there anything from the people? Anything at all from the people?
No objection.
Well, sir, you failed to appear in court. Amount of $100, 10%. Both attorneys have requested that this be made a personal bond, but the court is somewhat hesitant about that because there's been more than one capious on this matter. You don't show up to court, sir. That's a problem.
I show up to court.
Obviously not. I'm looking at times when you did not. Not just one time. It wasn't just one time. That's the problem. This matter appears to date back to 2019. You're not to have any contact, sir, with the Mike's Market located on Gratiot, 14383 Gratiot in the city of Detroit. Do you understand that?
Yes. Yes, I understand.
Based on the recommendation of both counsels, the court will amend the bond to $100 personal. We have a pre-trial date of August 28th, 2023, 8:30 a.m., 36th District Court in front of Judge Bryant. All right, sir, you may step away from the camera.
Thank you very much.
Black line, Dean, face the camera for that. Ron Nathaniel Hill.
Mr. Hill, this is case number 2305761, People of the State of Michigan versus Delvon Nathaniel Hill. Counsel.
Thanks, Judge. Good morning. Steve Benson for the people.
Great, on behalf of Delvon Hill, wait for where you stand here.
Court's going to enter a not guilty plea on his behalf. Is there anything as to bond from the people?
Judge, it's non-assaultive. There were 2 previous charges in 2 different years for forgery, as well as a CCW charge. Both of those got dismissed. Your Honor, the firearm in this particular case was registered to the defendant. There's a high likelihood of conviction, but at this point, Judge, the people aren't going to be objecting to a personal bond that court so inclined.
Okay, Mr. Rady.
Ask the person.
Okay. All right, Mr. Hill. These are very serious allegations, although they do not appear to be assaultive, at least on their face. Court is not aware of any capious history. Court will take the recommendation of people and your defense counsel and set a $3,000 personal bond. During the pendency of this matter, you are not to purchase or possess any firearms or any other weapons of any kind. Do you understand that, sir?
Yes.
You have a probable cause date of July 12th, 2023, 8:30 a.m., 36th District Court in front of Judge Robbins. Then you'd be entitled to a preliminary exam on July 19th, 2023, 8:30 a.m., 36th District Court, Judge Sabri. All right, sir, you may step away from the camera.
That's it. 20. Lee Thomas. Oh, you gotta get back. Full name, brother.
Thank you.
They gotta hear you. Understand that. Speak up.
Janelle Thomas.
All right. This is case number 2305762, People of the State of Michigan versus Janelle William Thomas. Counsel.
Thanks, Judge. Good morning. Steve Benson for the people.
Great, on behalf of Thomas, wait for where you stand here.
Court's going to enter a not guilty plea on his behalf. Is there anything else to bond?
Judge, non-assaultive, no priors. The firearm that was found was registered to defendant, but he doesn't have a CPL, therefore he finds himself here. Serious charges, however, Judge, we're not going to be objecting to a personal bond if this court so inclined to issue one.
We're asking for personal bond.
All right. Okay, sir. These are serious allegations. People have asked that you be given a personal bond, but sir, you're not to purchase or possess any firearms of any weapon or any other weapons of any kind during the pendency of this matter, sir. Do you understand that? Okay, you cannot have a gun at all,
I understand.
whether it's registered to you or not.
I understand.
Court is going to set your bond in the amount of $3,000 personal. You have a probable cause date of July 12th, 8:30 a.m., 36th District Court in front of Judge Robbins. You'd be entitled to a preliminary exam, which would be on July 19th, 2023, 8:30 a.m., 36th District Court, Judge Giles. All right, sir, you may step away from the camera.
Black line, face the camera for that.
Hold on.
What's your name, sir? Sir, what's your name?
Bruce Vassar.
Say it again. Oh. Okay.
You not voted yet?
They have the person in DLC.
Okay, sir, state your name again.
Bruce.
Okay. Calling. Calling case number 150456113, People of the State of Michigan versus Bruce Vassar. Appearances, please.
Morning, Your Honor. Samuel Lee Wright, environment P23-157.
May it please this honorable court, Philip Reagan, 57156 on behalf of Mr. Bruce Bassett.
Okay.
Formal reading, we understand you.
Okay, not guilty plea will be entered on behalf of your client, will set aside the capias. It looks like Mr. Vassar capias on December 14, 2016 for a violation of probation for domestic violence case. Where has he been for the past 7 years?
Judge had talked to this matter, and I spoke with an earlier judge. This was a different older girlfriend, child's mother, I should say. But he says the judge thought everything was completed. He thought that the case was done back in 2016. I explained to him there were conditions for probation that he pled guilty to and he had to comply with. And that's the reason he was here today. His bond is $15,010%. So I think he now understands that, Your Honor, but he had explained that to him. He thought the matter had been resolved.
Is your client working?
Judge, he is currently not working at this particular time. He receives government assistance. He lives in the city, Judge. He has not seen this Jessica Stitt. He is Jessica Stitt, who is a complaint in this matter. They do not, for a better word, they do not deal with each other any longer, Judge. They have a child together, but they are no longer a situation.
All right. People?
Yeah, you say capias.
Yes, it doesn't look like I don't have the authority to change that unless I hear otherwise from counsel.
Well, Judge, I would ask you to, it's a misdemeanor, Judge Garrett's case.
It looks like a.
What I believe at one point Judge Jefferson was on that docket. She did the domestic violence misdemeanor. So this might have been a time, but this is, to my knowledge, a misdemeanor. And I would ask the court, I know Judge Garrett changed the bonds, but
Yeah, I just may add a few things. This defendant allegedly did the mother of his child and prior to October 22nd, 2013, he was convicted of domestic violence as well as his spouse at the same time. Now, this has been played out for a number of years, and we would have no objection to a high personal bond with this incident without any contact with any of the complainants.
Is it one complainant or two?
I don't know who the second one is.
You say complainant?
I just have the one, Jessica
Stinson. One moment.
Thank you.
No.
Counsel, does Mr. Vassar still live on the Bayless address?
No, Your Honor.
Is that the residence of the victim?
I am not, he does not live with the victim. I'm not sure if that's her residence, Your Honor. I apologize. I know Mr. Magistrate stays on Alden Street, in the city of Detroit now.
Okay, so there's no reason to go to the Bayless address?
No, no reason, Your Honor.
Okay.
Yeah, plaintiff living on Asbury Park during the time of this incident.
Okay. All right. Court's heard argument as to bond. Court is going to set a $5,000 personal bond in this matter. One moment. With the following conditions.
My man. My man. You.
Mr. Vassar, you're not to have any contact at all, verbally, in writing, email, or social media to Jessica Stinson. Is that correct?
Yes, sir.
You're not to go to her house or have any other contact with her. Do you understand that?
Yes, sir.
Okay. And sir, you have a review date, July 14th, 8:30 a.m. in front of Judge Garrett. You understand that?
No, you said 9:14?
I said 7:14.
7:14.
If I said 9, I misspoke. Your review date's 7:14 in front of Judge Garrett at 8:30 a.m. Mr. Vassar, do you have any questions regarding your bond and or court dates?
No, sir.
Okay. Anything else with counsel?
Thank you, Your Honor.
Okay. Okay. All right.
Okay.
Yeah. There's a lot going on. That was Mr.
That was best.
Sir, state your name.
Shaquille Bledsoe.
Shaquille Bledsoe. Okay, sir. You've got some traffic matters in which you failed to appear in court for, and therefore capias was issued for your failure to appear. We're going to set aside the capias, going to enter a not guilty plea, and give you a personal bond on each of these matters. They are ticket number P1284418. Driver's license never acquired and insufficient or defective lights. You have a
That one, that license still on the back.
Oh, I'm sorry. Okay, correct that. Just the driver's license never acquired. You have a pretrial date, 8:30 a.m. August 2nd in front of Judge Yancey. Do you understand that? Do you understand that, sir?
Yes, Your Honor.
And also, you have a right to remain silent. You have a right to counsel. If you can't afford one will be appointed for you. And this misdemeanor count has a maximum penalty of 93 days in jail and a $500 fine. Again, your pre-trial court date is August 2nd, 8:30 a.m. in front of Judge Yancey. Any questions regarding that?
No, sir.
I'm sorry?
No, sir.
Did you understand what I said?
I heard.
I said, did you understand everything I just said?
Yes, I heard.
Okay. Now we're going to go on to your other matter. People of the state of Michigan versus Shaquille Bledsoe, case number 220555165. Appearances, please.
Samuel A. Ragland, P 23-157.
Not guilty plea will be entered. A case will be set aside. It looks like this is an adjudicated matter that Mr. Bledsoe failed to appear for a review date. Is that accurate?
Judge, he had a CCW charge, pled it down in front of Judge Robbins with misdemeanor. Was placed on a 1-year probation with certain conditions. Part of it was to pay fines and costs. He paid some of the fines, Judge. He has a balance of $522. That's what his bond was set at on April 17th of this year. That is the case bond, Judge, right now.
Correct.
So, Judge, he's not working presently. He did pay somewhat, some of the costs, Judge, not all of it, obviously. So I'm asking, he'd be given an opportunity to pay. He's adjudicated, pled guilty, taking responsibility, just needs to pay the rest of the money.
One second. People, argument for the people?
Yeah, we have no objection to the person buying this matter.
Okay, one moment.
It's, Roberts case.
Is that me or you?
Judge Roberts case.
Mr. Reagan, have you heard from Mr. Reagan? Have you heard from Judge Robbins with respect to any bond reduction?
Judge, I have not, but I will reach out if people so have no objection. I'm going to reach out to Judge Robbins to see if he has an objection to this.
Now, you go with this and keep moving.
Okay, in the interim, while you do that, I'm going to continue.
It's a misdemeanor, Judge. I'm sorry. So it's still for Judge Robbins.
Yes.
So it is a misdemeanor. That is a very good point, Magistrate.
Okay, we're going to continue the bond set by Judge Robbins at $522 cash, no surety, until I hear otherwise. The condition of the bond is you're not to possess or own or purchase any firearms or any other weapons. You understand that, sir?
Yes, Your Honor.
Okay.
Here, beside your signature. You done with him?
Yes. Mr. Bledsoe, I'm going to continue Judge Robbins' bond of a $522 cash bond, no surety. You have a July 12th review date in front of Judge Robbins at 8:30 a.m. Now, we may recall your case if your counsel has obtained authority to reduce the bond, okay?
Just in case we do not hear back, because 522 is unimportant. Mr. Bledsoe at this time. Hopefully we won't get to that, Judge, but I just want to take on.
So the date is July 7th.
So just so the court's clear, you're saying that this $522 bond, cash bond is unaffordable for your client, and you're requesting a bond redetermination hearing, which would be July 7th, 2023 in front of Chief Judge McConicle. Is that correct?
Judge, that is my request at this time.
Okay. Anything else from the people? Okay, Mr. Bledsoe, free to step aside, please.
Thanks, man. Let's go. This way, man. This way, Jim. Step to the side. Black line face the camera for Amari Jamil Jennings.
You said Imari Jennings?
Amari Jamil Jennings.
Calling case number 2305760. People State of Michigan versus Imari Jamel Jennings. Imari Jamel Jennings. Imari Jamel Jennings. Appearances, please.
Thanks, Judge. Good morning, Steve Vincent for the people, P71917.
Judge, may it please the court, Bill Brady, 257-156 on behalf of Mr. Amari Jennings, waive the formal reading and
Okay, the court will enter not guilty plea in this matter. Argument as to bond.
Thanks, Judge. The people in this matter are going to be asking for a $30,000 cash bond, tether and home arrest. I'm sure your honors had an opportunity to read the investigative report. The people have also had the opportunity to speak with the complainant at length in this matter, Judge. Regarding this particular incident, allegedly, the defendant gets drunk, appears at the complainant's home, tells the complainant through a window at her house, quote, watch this, and then he subsequently pours gas on her car and lights it on fire. Then he turns back, he doubles back to the house, and he says to the complainant, quote, that ain't all I'm getting. Your Honor, while the defendant then subsequently leaves the residence, the police were called through 911 by the complainant. The police actually observe the offender on the roadway before they get to the residence. They end up apprehending him, putting him in the back seat of their vehicle, where he subsequently ends up kicking the back of the squad car multiple times, causing damage. Your Honor, after speaking with the complainant, it's clear this defendant not only has assaulting propensities, but he also has a drinking problem. Allegedly, this stuff occurs when he's intoxicated. Now, Judge, if I could just clean up some administrative matters. This defendant, I don't know why this is not included on this particular complaint. It should be enhanced as a result of the fact that this defendant was convicted of carjacking and unarmed robbery in 2009. As well, Your Honor, he ended up having an 07 and a 15 misdemeanor domestic violence convictions that this complainant was the complaining witness in.
What year were those convictions?
Your Honor, those were in 07 and 15. As well, Your Honor, we just had, this is just for purposes of speaking about the complaining witness, we just had a 2023 matter with 8 counts that were all dismissed. Your Honor, those counts included weapons, felony firearms, domestic violence, assault with a dangerous weapon, assault with a dangerous weapon, so on and so forth, so on and so forth. And the same complaining witness in this case was the complaining witness in that case too, Judge.
And what was the date of that case?
Your Honor, that offense occurred in May 1st, and it was dismissed May 15th at the exam, Judge.
Of this year or last year?
This year.
This year, okay.
This year. Same complaining witness, she's scared, Judge.
And you said
we have those 2 prior domestics. Again, I don't know why this isn't enhanced. Your Honor, at the very least, this defendant is a clear danger to the complaining witness. Your Honor, this is a pattern that now we see as a result of these prior convictions. And I could have gone back even further because there were prior convictions prior to the 07 domestic violence, although those had to do with firearms and controlled substances. So, Your Honor, it appears as though this defendant just won't let this go, won't let the relationship go, continuously gets intoxicated pursuant to what the complainant had told me. In regards to this particular defendant, the people do feel justified in asking for that cash bond as well as the tether and homeless.
What was the cash bond amount you requested?
$30,000.
Cash surety or just cash?
Cash.
Okay, one moment. Reagan?
And I don't have the privy brother counsel,
because I do know that she stated that they've known each other for there's something that, there, that she is staying for 20 years. I don't know what happened in May, Judge. I just know that it was dismissed. So, and in my understanding, she doesn't want to press charges, but I can't speak on that, Judge, because I haven't spoken with the complaint. But I can say this, Judge, alcohol seems to be maybe a contributing factor to the relationship issues that keep happening between, my client, Judge, and Mr. Richardson. And when we take alcohol out of this equation, I don't know. They've been together for 20 years. Something in 07 occurred.
Mr. Reagan, let me interrupt you. When you said they've been together, they
They've
dated?
known each other. I'm sorry, 20 years.
Okay, let me clarify. They've known each other for 20 years. At any point during that 20-year time period, have they lived together?
Judge, she is a living girlfriend now. They live together now. So
They live together now?
yeah.
Any children in common?
Judge, they have 4 children. Mr. Jennings, are those children, those 4 kids by Mrs. Richardson? Okay, so no kids in common. So that's something that they can.
And as Mr. Reagan, just to further clarify, so the court has a clear understanding, this is the Gable address you're talking about, that's been the residence for both parties?
That's my understanding, Judge. But Mr. Jennings told us he can go somewhere else. I mean, this is not when you have alcohol and you are have taken a Hawaiian punch bottle and poured some stuff represented on top of the car, and these are allegations. Obviously, we're still early in this case, but there's some issues. As the brother counsel said, there was another case, and that case, I don't want to say anything happened because it was dismissed. But the relationship is not good. He needs to go somewhere else. What I would suggest, Your Honor, is a GPS tether for Mr. Jennings. So we know that Mr. Jennings cannot come within 500 feet of the Gable residence. He can't come near it. And I think that he can't drink. Let's put that on there too. No drink, no alcohol. I think that has a lot to do with, maybe his temperament, mood, allegedly, because again, 20 years is a long time to be with somebody, Judge, whether it's in an alleged abusive situation or not, but it's still a long time. And I'm hoping that this tether will keep him away and it'll keep her. I mean, they will not talk and this thing will get resolved. Now, whether she shows up for the next court date, I don't know. It's going to go to Judge King, I'm sure, for PCC and exam. His last case was dismissed within 2 weeks. I don't know, Judge, and that's not for me to say. But here I'm asking for a high personal bond with a tether, and maybe even house arrest, Judge. He's not working. He's disabled. He just had 2 heart attacks. So he's not working right now. So we can put him on house arrest with a tether. And I think, Judge, he can have time to think about, his next relationship on Ms. Richardson.
Sure.
When he ended up pouring gasoline on top of that vehicle, he not only put the complainant in danger, he ended up putting everybody close to that vehicle in danger, meaning those houses, those people, if they were sleeping, those kids, if they were in those houses. So, Your Honor, it's not just the complaining witness here. It is the community, the residential neighbors. Not only that, Judge, there is going to be a high likelihood of conviction here, twofold. One, this just doesn't have to do with this arson. What's lost in this is the fact that when the police ended up coming in, he ended up getting into that vehicle. Your Honor, I mean, I don't know if I can go so far as to say resisting, because that's not what he's being charged with, but you saw how he was behaving even when the police attempted to apprehend him in the police car. Not only that, Judge, this whole gasoline thing, which I think just based on defense counsel, and I don't want to put words in his mouth, the whole idea that this individual actually poured the gasoline has been corroborated by green light evidence that shows he went to a gas station and actually filled up this container with gasoline, which he was identified with doing. So he went to that gas station, poured that gasoline in, came over to a car in a neighborhood, poured gasoline on that car, and lit that car on fire. Now, you know what? I think we all agree the relationship is unhealthy, but this defendant put more than just this complaining witness at risk. But it is unhealthy, and there have been prior assaultive convictions, and now we have this. And we also have one other thing I want to mention, or I'll digress and move on. I don't know if it's going to end with this situation, because I'm sure, as Your Honor read the investigative report, this defendant, quote, said, "That ain't all what I'm going to do to you." And that was after he ended up lighting the car on fire. So who knows what else this defendant has in store. Now, Your Honor, I understand the intoxication is a part, and I concede to that fact because I had a conversation with this complainant. But Your Honor, with all due respect, the prior convictions, now with this, and with the threat of potentially what could happen in the future, this isn't going to end well. And the people are asking for that bond in order to protect the complainant, in order to protect the community.
Mr. Vincent, you said you spoke with the complaining witness, is that correct?
Yes,
did she give you any indication as to whether she's fearful or not of the suspect, of the
She is
defendant?
fearful, especially when he drinks.
Okay.
Judge, and I didn't have, and I had the pleasure to speak with the complainant, but I do trust brother counsel and his word, Judge. But I think somewhere in between, the conversation and her thoughts, and I don't want to speak for her, is that she's afraid of him when he drinks, Judge. And drinking is a trigger for him. And if he doesn't drink, Judge, I don't know, I'm not gonna say she's not afraid of him, because I don't want to go that far. But I think that drinking, in her mind, if this man drinks, I don't want to be around. I don't want to have anything to do with him. But when he doesn't drink, he's probably a decent guy for the last 20 years. But I don't want to say that as a fact, Judge, because I didn't speak with her, but that's the kind of sense I get from her not appearing on May 17th and different things that I kind of see from doing this. And again, we can't look at what would have happened. We have to stay within the four corners, because as brother counsel said, it could have been some very bad things that happened all around, but it didn't. So I don't want to go that far, Judge, to think what didn't happen. A lot of things happened. But what did happen, the allegations are pretty serious. They are, so I'm going to leave it at that, Judge.
All right. Thank you, Mr. Reagan. Thank you, Mr. Vincent. Good. You've argued very, very well in respect for both your clients, so to speak. The court is really concerned not only about the safety of the complaining witness, but as Mr. Vincent alluded to earlier, with the arson, the safety of the community. And that is buttressed by the fact, given Mr. Vincent's representations, that there have been, although not convictions, previous allegations of domestic violence between these two parties.
Convictions.
There are convictions?
07.
Okay.
07 and 15.
Okay, I stand corrected, because the last one was dismissed, but 07 was a conviction.
23 was dismissed,
Right.
the 15 and 7 were convictions.
Okay, the court stands corrected. Coupled with the fact of the threats, alleged threats stated by the suspect in the investigative report, gives the court pause that this Mr. Jennings is capable and willing, based on his verbal threats, to do something further beyond just setting the vehicle on fire. So for those reasons, I'm concerned not only for the safety of the complaining witness, but the safety of the community in that matter. In light of that, the court will set a $40,000 cash, no surety bond with the following conditions. Mr. Jennings, you're not to use any alcohol, any marijuana, or any illegal controlled substances. Do you understand that?
Yes, sir.
You're not to have any contact via verbally, in writing, via email or social media to Tawanda Richardson. Do you understand that?
Yes, sir. Yes. I can't get out, man. I don't have a job.
And you're not to possess any firearm or other dangerous weapon. Do you understand that while this case is pending?
Man, don't run me up. I can't get out of jail, man. That man just sit up there and lie on me like that, man.
I'm sorry.
Violate my rights. I've been here for 5 days. My rights been violated. I've been rearrested, but I never was arrested.
Mr. Jennings. Mr. Jennings.
Yes, sir.
Okay. Did you understand what I just said?
Yes. Can I
Mr.
say one
Jennings.
thing?
Not yet. Not yet. Not yet. Did you understand the conditions of bond while this case is pending so far?
Yeah, I understand that.
Okay. So you're not to have any, I just want to make sure when you went off on, you stepped aside, you're not to possess any firearm or other dangerous weapon while this case is pending. Do you understand that?
Can we talk about them violating my rights, my due process?
Hold on, Mr. Jennings, hold on.
You understand that, sir?
Oh, yes, sir.
Okay. And you're not to have any contact, I stated that any contact, verbal, oral, via email or social media to Tawanda Richardson. Do you understand that?
Yes, sir.
Okay, if you're able to make bond, you will have a GPS tether and under house arrest. Sir, do you understand that?
Yes, sir.
Okay.
I'm sorry, man.
Now, 1 second. I'm going to get to your court dates. You have a bond redetermination hearing in front of Chief Judge McConaughey, July 7th, 2023 at 8:30 a.m. 9 o'clock. I'll strike that, 9 a.m. You have a probable cause conference July 12th in front of Judge Jefferson, and you have a right to a preliminary examination in front of Judge Jefferson on July 18th. Both of those dates are at 8:30 a.m. Now, Mr. Jennings, you had a question. Did you want to?
Well, Judge, I think what Mr. Jennings wants to
Yes.
say, because he was arrested on this matter, he was held and he was released. He hadn't signed a warrant. He was released. Then before anything else happens, he's getting released, they just rearrested. They never let him out. They never let him out of the cell. They never let him go. He's rearrested right in the DDC again, Judge, which is a clear violation I would believe, Judge, is 72 hours. But I think that's what he wants to point out. These are constitutional issues that his lawyer is going to take up at the next hearing, I'm sure, Your Honor. But I just want the court to know that you know, he never got out. He never got out of the cell. Once he was arrested and not charged, and then rearrested him again after the time limit expired, and now he's back in court.
Okay.
I think that's what he wanted to state to the court.
All right. And one other matter, DDC, please mark as file medical for the reasons stated previously. Okay. Anything else from $40,000 cash surety? Cash, no surety. GPS tether house arrest if he's able to make bond. Okay.
So just cash, straight cash.
Yes.
Yeah, redetermination here, please.
Yes.
That's on the board.
Yeah, July 7th.
July 7th, I'm sorry.
That's what happened.
Thank you so much.
Okay.
See if he's ready to do this one.
Aries Evans.
See if Mr.
Yes.
Mr. Reagan,
Anybody.
are you ready to do Mr. Evans?
Yes, Your Honor, I believe the MPLC is ready on this. Yep, ready on that.
Okay. Counsels, do you want me to call all three cases?
Yes, please. Yes, please.
Okay. Sir, state your name. Mr. Evans, state your name for the record, please.
Aries Evans.
Okay. Calling case number 210622122. People of the State of Michigan versus Aries Kashawn Evans. Case number 2. Calling 210622121. People of the State of Michigan versus Aries Kashawn Evans. Case number 3. Calling 210457271. People of the State of Michigan versus Aries Kashawn Evans. Appearances, please.
Bar number P23-157 on behalf of the people, Your Honor.
And Your Honor, Austin Gregory, PA 5193, on behalf of Mr. Evans, who is present by Zoom, to be aware of his constitutional rights. Ways more reading and stand.
Thank you, Mr. Gregory. The court will enter a not guilty plea, waive the formal reading of the reading of the complaint has been waived, enter a not guilty plea. Is any preference in which case to go first, or the order I call them in terms of arguing for bond?
Your Honor, I'm ready to argue for bond on all three.
On all three? Well, you, Mr. Gregory?
Thank you, Your Honor.
Okay, go ahead then.
Your Honor, this incident occurred for all three of these cases in Wayne County Jail after Mr. Evans, the defendant, was placed on $500,000 bail on August 13th, 2020 for 10 felonies, 2 counts of assault with intent to commit murder, 2 counts of grave bodily harm, less than murder, dangerous weapons, assault, carrying concealed, and 4 counts of felony firearms. Okay, so he's in jail, and what happens, Your Honor,
Mr. Ragnar, let me stop you there. Are those cases still pending?
no, he's been sentenced on it.
He's been sentenced on those.
I'm gonna get to that.
Okay.
I'll tell you right now, Your Honor, he did plead down from the charges that I mentioned to assault with intent to do great bodily harm, concealed weapons, felony firearm, I'm sorry. He's been sentenced to 5 years to 10 years on great bodily harm, less than murder. And he's also been sentenced to 2 years to 2 years on a weapons, felony firearm. He is currently incarcerated in the Michigan Department of Corrections. His earliest release date is 8/8/2027, and his maximum discharge date is 8/8/2000. I think it's very important, Your Honor, that these cases have $10,000 cash bond, $30,000, and what happened on
He assaulted, excuse me for interrupting, he assaulted 2 officers and then 1 civilian, not civilian, but another inmate?
Yes.
Okay.
And that inmates, all this has been on video with the inmate that got assaulted. They can see the defendant punching him above his face and his torso. The other one happened where he didn't follow directions. He seemed to always not do what he was asked to do or told to. Okay. And one incident, he was told to leave the area. He threw a liquid up from a cup and hit the officer on his arm. And then as the officer kept going, he spit on him and hit him in the back. And then we had another incident where he was in the day room attempting to commit suicide.
I'm sorry, what now?
Attempting to commit suicide.
He wasn't.
He was going to commit
Okay.
suicide. He tied some sort of a blanket or something on a pipe above him, stood on the table. He said, anybody comes by me, I'm gonna stab it to death. He had a the officers had been telling him now. And then he got and so on, grabbed him by the legs. He fell, he just didn't poke him at all. They told him to calm down, he tried to put your hands behind your back. He refused multiple times. Finally, they yelled taser 3 times. They tased him, and that's how they got him under control. In each of these incidents that happened at the Wayne County Jail, He was never cooperative, never followed orders until just at the very last moment. If in fact he gets out or his cases last beyond.
Well, let me interrupt you there. Is it fair to say that whatever bond is set here, he still will remain in the jurisdiction of Michigan Department of Corrections? Is that fair to say? Okay.
But I think that a $10,000 cash bond in each of these would be appropriate in this matter. Thank you.
Okay, Mr. Gregory?
Your Honor, we do ask for a nominal bond in this case. I apologize, Your Honor. We just ask for a nominal bond.
Nominal meaning how much? $1,000 cash?
Correct.
Okay, one moment. Okay.
Hey, take it easy, bro. He's saying it like that. Attention, man.
Mr. Gregory, if the court adopts your recommendation and sets a nominal bond, would any bond be unaffordable?
That's correct, Your Honor.
Okay, anything else, Mr. Ragnar?
Nothing further.
Okay, the court's going to adopt the recommendation of Mr. Gregory and have a nominal cash surety bond of $1,500. Yes, for each case. Well, thank you. Thank you. And I'll get to the court dates momentarily. Okay, now, Mr. Evans.
Yes, sir.
On each of these three cases, well, on the two cases, on let's see, on case 210622122, you're going to have a bond redetermination hearing on July 7th, 2023, 9 a.m. in front of Chief Judge McConicle. On this case as well, you have a probable cause conference hearing in front of Judge Giles at 8:30 a.m. via Zoom. And you have a right to a preliminary examination at 8:30 a.m. July 18th in front of Judge Giles. On case number, yes.
You mentioned the determination hearing on the first case you mentioned. What was it?
July 7th?
And then the pre-trial is also the same day?
No, the probable cause conference is July 12th, and the preliminary examination is July 18th.
Thank you very much.
Okay, no problem. On Case number 210622121. Mr. Evans, you have a bond redetermination hearing also on July 7th, 2023, 9 a.m. in front of Chief Judge McConicle. The probable cause conference date is July 12th via Zoom in front of Judge Giles. And also, you have a right to preliminary examination July 18th in front of Judge Giles. On the last and third case, 2104521, you have a pretrial date, August 24th, in front of Judge Bryant via Zoom, is my understanding. And I believe you get a bond redetermination here for this one as well, if I'm not mistaken. Is that correct? Yeah, on July 7th, 2023, 9 a.m. in front of Chief Judge McConicle. Mr. Evans, do you have any questions regarding your court dates or bond?
Yeah, I want to know, like, if I'm able to come to my court dates in person instead of over Zoom.
I believe it's going to have to be through Zoom unless your counsel tells you otherwise.
Okay.
Okay. Is there anything else from counsel?
Nothing further.
Okay.
Thank you very much.
Thank you. Thank you, Mr. Evans. You can step aside.
Quincy Woodard, sir.
Quincy Woodard.
How you doing, sir?
I am fine, Mr. Woodard. How are you?
I'm doing fine, sir. Really am.
Okay, sir, state your name again for the record.
Quincy Woodard.
Okay, Mr. Woodard, you have some traffic matters in which you missed your court dates on. A capias was entered for your failure to appear. I'm going to set aside those warrants, enter a not guilty plea on your behalf, and you're going to be given a personal bond, no amount on each of the tickets. They are P13083332, driver's license never acquired, and on P1332582, drove while unlicensed. On each of these matters, you have a right to remain silent. You have a right to counsel. If you can't afford one will be appointed on your behalf. And on each of these matters, you have the maximum penalty is $500 fine and or 93 days in jail. Your next court date is a pretrial conference in front of Judge Taylor, August 1st. You understand that?
Yes, sir.
Okay. All right, now calling case number 230-57683, People versus Quincy Lee Woodard. Appearances for the record.
Thanks, Judge. Good afternoon. Steve Vincent for the People, P71917.
Your Honor, Austin Gregory, P85193, on behalf of Mr. Woodard, who is present by Zoom, has been made with the constitutional right. Waive from reading, stand, not the court enter not guilty plea on his behalf.
Okay, court's going to enter not guilty plea on behalf of Mr. Woodard. Argument as to bond.
Thank you, Judge. The people in this matter are going to be asking for $10,000 cash, no surety, UPS tether, home arrest. Your Honor, I'm sure had the opportunity to read the investigative report. We have a defendant who ran from the police after the police ended up observing him. Defendant sees this. Defendant takes off. Police call for him to stop. He doesn't. Pursued on foot. Your Honor, they have to go through alleyways. At that point, Judge, the defendant tosses a firearm that he has on his possession. I think we have a confession of that. He's caught and the firearms recovered. Now, just for housekeeping matters, the enhancements judge failed to note a couple of things which are very interesting. In 2007, on top of the 3 convictions, there's also an enhancement for pleading guilty with assault with intent to murder that, Your Honor, he ended up being found guilty of, as well as in 2002, the complaint ended up failing to mention that there was a home invasion second-degree conviction, which he was found guilty of. Now, Your Honor, the people could go 2 different ways with this. We could argue danger as well as flight. We'll start with flight first, based on the fact that this defendant was running from police officers when he noticed them observing him, subsequently tossing out a firearm, which he knew that he shouldn't have been possessing, not stopping when the police asked him to stop, Judge, and ultimately running as far, I guess, as he could get before the police apprehended him. Regarding the danger, Judge, shouldn't have had a firearm in the first place. And with that being said, he ends up tossing a firearm, potentially loaded, and the people can't argue one way or another, but he ends up tossing a firearm into some type of vacant area, which, Your Honor, don't know whether or not potentially, and you know what, defense counsel is going to argue, hey, this isn't potentials, this isn't assumptions, but if we toss a firearm somewhere and it's not collected, who knows who could have put their hands on that. Now, with that, Your Honor, I believe the flight argument justifies the request for the cash bond. I also do find that there's a danger of this individual based on his prior convictions, as well as how this whole incident took place. And we again would just be asking for that 10,000 cash, no surety with tether house arrest.
One moment, Mr. Gregory. What was the date of his most recent conviction prior to this incident?
Yeah, Your Honor, I believe the 07 where the have notice comes in talking about the carjacking, as well as, I think that's where we end up getting to the 4th because of the 3 convictions. But for whatever reason, and the powers to be, maybe it just fell through the cracks, proverbial cracks.
But I'm sorry, Mr. But all his prior convictions are from 2007? Is that?
Yes, sir. Yeah, that one, but what wasn't included, Judge, was that A one.
Right, but
Yeah.
But the point of it is that they all were 2007.
Yeah, as well as that
right
conviction.
Okay,
Correct.
so
we haven't had anything since.
That's my question. Correct. Okay,
Judge, that's correct.
All right, since 2007, he has not been convicted of anything.
No, nothing, Judge. We have the assaultive convictions prior to, but nothing since.
Okay, I'm sorry, Mr. Gregory, proceed.
Your Honor, one, this is a non-assaultive allegation. Arguing that danger seems like a far-fetched one. This is a non-assaultive allegation. He does have he does have 1-year-old child, Your Honor. He's 39 years old, and more importantly, about his type of community, he helps homeless people in the area work on their houses or work on houses and provide some life. As to the argument that he ran, there's nothing illegal about running before police arrest him. There's nothing. That's been settled. A person is allowed to run, a person is allowed to not answer a police officer, a person is allowed to leave them, like it's a voluntary conversation. Once the police put him in custody, there's no argument that he was combative or uncooperative. So I would argue that this is not a case of where he presents as a flight risk, nor does he show a danger based on these charges. So we're asking for a personal bond in this case. Oh, and
where is he employed?
It's at Ford Field and Little Caesars, Your Honor, as a janitor.
Next door.
Oh yeah, we're gonna listen to the lawyer.
Anything else, Mr. Vincent?
No, Your Honor, the people just rest on its previous argument.
Okay, one moment.
Speak to me. Yeah. Look at the prosecution. Got 2 jobs. I obtained 2 licenses from the state of Michigan. So you good on that? I want to see that. Not you me. I'm sitting right there. See, even he can't do nothing against that. He can't touch it. Where you go? Overtime.
This is not your case. This is just for you to buy. All right, baby.
What's his name?
Okay, Mr. Gregory, what are your client's work hours?
Mr. Wilbert, very briefly, what are your work hours?
They vary because due to whatever time the teams play, what time I start working varies due to the schedule of the games. And a lot of those convictions was overturned that he mentioned. In my case, the attempt murder and all that was overturned on appeal. Carjacking, all was overturned. I never got convicted for those. It was overturned.
Oh, okay, Mr. Woodard. One second. Mr. Woodard, I'm gonna take a chance on you. And give you a personal bond. And these are the reasons why.
I changed my life.
Well,
Mr. Woodard, you please do your best to remain silent at this point.
Yes, sir. I'm sorry, sir. I'm sorry. Sorry.
Thank you.
okay, Mr. Woodard, I'm going to give you a personal bond. I'm going to articulate on the record the reasons why the court is going to do this. As Mr. Vincent indicated, your last conviction were nearly 2 decades ago in 2007. You had a series of serious felony convictions. And so for the almost 20 years or so, nearly 20 years, it doesn't appear that you've had any violation of any law or any problems with following and abiding by the law. Specifically with respect to this incident, you weren't inherently, aside from having a weapon on you, you weren't doing anything wrong. You were at the gas station, presumably minding your own business until the police saw you and saw that you had a gun on your person and you fled. So in light of this, notwithstanding your previous convictions from 2007, I don't think you're necessarily a present danger to the community. However, I do have some concern about you being a flight risk, given the fact that you fled once officers approached. And then you threw the gun out, you threw the gun away. I'm inclined to give a tether. Well, the court's issue with the dilemma is I'm inclined to have a personal bond with a tether, providing his work schedule, but given that he works at Ford Field, that's going to be difficult. Is that not correct?
That is correct, Your Honor. Again, the varying hours, as Mr. Wooders indicated, does make it a little bit more difficult to.
He doesn't have steady. Yeah, I understand, but I'm sorry.
Mr. Woodard, what time what is a time that you normally start?
I normally start at 5 p.m. and then the next day I will start at 11.
AM or PM?
It's either 5 or 11. Those are two times I start work.
Okay, is this on game day or the day after, or when does he work one day a week, or?
These are game days. These are game days or event days when they have events at these particular places I work, at Little Caesars, or I'll go work at Ford Field, or I'll go work at Comerica. The company I work for works for all three of those arenas.
So, Mr. Gregg, I understand he works potentially football games, baseball games, or any event. Concerts, anything. Is that correct?
That's correct, Your Honor.
And typically, Mr. Gregg, how many days does he work a week? Just typically. Yeah. I don't.
Mr. Woodard, do you typically work? How many days do you work a week?
7 days.
7 days?
Yes. All depends on the event. Sometimes at the most 6 days, 7.
Okay. Well, in light of his work schedule, okay. I'm going to give him a $10,000 personal bond with a GPS tether, and I will allow him to go to work and back home once the work schedule is coordinated. In addition, Mr. Woodard,
Sir.
You are not to possess any firearms.
Yes, sir.
Okay, all right. You're not to possess, purchase, otherwise obtain any firearms. You understand that?
Yes, sir. Your Honor, I speak.
Talk to your counsel first.
Mr. Woodard, I would advise against you speaking unless it is to or your court dates. But I would advise that you remain silent at this time. If it is not,
I think it's important for the judge to know that I have state license as an asbestos worker throughout the day. And you don't necessarily have to put me on tether to go to those jobs because I'm a state. I got state license in asbestos and abatement lead throughout the daytime as well. I earned those licenses.
Okay, well are those jobs you have?
Yes, sir. I work
Are
for
you,
Mr. Rice.
hold on. Are you compensated for those jobs?
Yes, sir, I am.
Okay, well, that'll be incorporated with the other jobs you have with respect to Ford Field, Comerica Park, and otherwise Olympia Entertainment. Okay? But you have a tether, GPS tether, but allow you to go to work and back home whenever your schedule is coordinated with the appropriate individuals.
Yes, sir.
All right, now, your probable cause conference date is July 12th, 8:30 a.m. in front of Judge Jefferson. You have a right to a preliminary examination July 18th, 8:30 a.m. in front of Judge Jefferson.
Yes, sir.
Is there anything else from counsel?
No, thank you, Judge.
Nothing further, Your Honor.
All right, thank you.
Come on, Ben. Come on, brother. Come on. It's gonna be all right. Step on that black. Say your name, Ben. Oscar Benning.
Mr. Benning.
Yes.
What's your name for the record again?
Oscar James Benning.
Okay, calling case number 230448883. People of the State of Michigan versus Oscar James Benning. Appearances, please.
Good afternoon, Steve Benson for the people.
Austin Gregory, TA 5193, on behalf of Mr. Benning, who's present by Zoom. Is a mailer of his constitutional rights away from where he stands mute, not to put enter not guilty.
The court will enter a not guilty plea on behalf of your client. Argument as to bond.
Your Honor, this is a case of conflicting allegations. However, we do have a witness here, defendant's other grandson. One grandson's a complainant. There's another grandson who's a witness. Allegedly, sees, Your Honor, the defendant grandfather assault his brother, who's the complainant grandson, hitting him in the chest, apparently with a closed fist, and then attempting to grab a metal pole to use it potentially for an assault. Now, in full candor, Judge, after reading through the investigative report, a couple of things that people would like to note uncharacteristically. One of which is it was the defendant who ended up calling the police, yes, it's this defendant who ended up calling 911, separated himself from the incident, as well as the fact that this defendant was the only one who had an alleged injury, Judge. Now, with all that being said, Your Honor, I'm sure this is going to get hashed out through the court system. However, reading everything, putting everything together, the people are prepared and comfortable asking for a personal bond in this matter with the no contact throughout the pendency of this case. Your Honor, so chooses to adopt the people's recommendation.
Okay, Mr. Vincent, I got a question. It looks like the complaining witness and the victim in this case and the witnesses, they're still minors?
Well, that's correct, Judge. It appears as though these individuals are all living together. The people did have an opportunity to look more extensively, not just through the investigative report, but through other reports in this matter, and not to divulge too much because the people don't have anything to produce for defense counsel. It appears as though there were other things going on, your judge. And, you know, Your Honor, just on its face, I can see where Your Honor may have, some reservations and hesitations. And the people, they do as well, because you know what, this is an assaultive type matter.
Well, Mr. Vincent, here's the court's dilemma.
Sure.
You got minors in the house that need to be residing in the residence and need to be supervised. And if a personal bond, Mr. Benning is going to, are you saying?
I believe the minors have a mother in that house as well, Judge.
Oh, so the mother lives there as well? Okay. You're dressed.
I completely understand where Your Honor was going with that, and the people should have vocalized that, articulated it, but the minors would not be left alone, Judge.
Okay.
That there is there's a parental figure that's present.
I didn't want another home alone situation.
Absolutely, Judge.
Okay.
I completely appreciate you bringing that up.
All right, Mr. Gregory, go ahead.
Your Honor, we do ask for a personal bond. Mr. Benning understands that you need to find alternative lodging as well, even though it is his home, but he does understand the situation. So we do ask for a personal bond, Your Honor.
Okay, Mr. Vincent, does Mr. Benning have any history or any past criminal convictions?
He does, and I know, Your Honor, this takes those types of matters into account, but we don't have a conviction since '99. It was a controlled substance, Judge. And then if you want to go all the way back.
No, that's enough. No, that's enough, 1999. And are there any pending cases, Mr. Vincent?
No, Judge.
Is he employed, Mr. Gregory?
No, Your Honor, he
receives disability?
That's correct.
Okay, and refresh my memory, Mr. Vincent, what was your recommendation, personal bond?
It was personal bond with no contact through the pendency.
And Mr. Gregory, you, any objection to that?
No objection, Your Honor.
Did you request a tether?
No, I did not in this instance, Judge.
Okay, obviously no objection.
No objection.
Okay, the court's going to adopt the recommendation of the People and Defense Council. Mr. Benning.
Yes.
I'm going to give you a $5,000 personal bond.
Yes.
You're not to have any, as a condition of the bond while the case is pending, you're not to have any contact with Jamari Benning. Do you understand that?
Yes.
And you're not to go back to the 8,000 block of Chatham. You're not to go back to that location. Do you understand that?
Yes.
Your Honor, I would ask for a one-time police escort so that he can collect his belongings.
Okay. One moment. Okay, Mr. Bennett, you understand you're not to return to the 8,000 block of Chatham. Want to allow you one-time police escort to collect your belongings. Do you understand that?
Yes.
Okay, Mr. Benning, your next court date is July 14th in front of Judge Garrett at 8:30 a.m. Do you have any questions regarding your court date and or bond conditions?
Well, I don't have any problems with that.
Okay, anything else from council?
No, thank you.
Mr. Gregory? All right, thank you. Step aside, Mr. Benning. Okay, DDC?
Yes, sir.
See you on the woman's side.
Yes, sir.
All right, thank you. All right. What's your name, ma'am? Brianna Allen? Yes. Okay. Miss Allen, you have a traffic matter in which you missed your court date and the case was issued for your failure to appear. I'm going to set aside that warrant and enter a not guilty plea on your behalf and give you a personal bond on this matter. It's ticket P1, ticket P1214347, driving an unregistered or unentitled motor vehicle, driving while license suspended, and no insurance misdemeanor. You have a right to remain silent. You have a right to counsel. If you can't afford one, one will be appointed on your behalf. These are misdemeanors. These are misdemeanor offenses, which have a maximum fine of $500 and or 93 days in jail. Do you understand that? Okay. Your court date, your next court date is a pretrial date on August 2nd at 1:30 p.m. Well, it doesn't say what judge. Courtroom 533. Okay, do you understand that? Your next pretrial date is for the tickets, August 2nd, 1:30 p.m. in courtroom 533. You understand that? Yeah. Okay. Now on to your more serious matter. Calling case number 2204494. People of the state of Michigan versus Brianna Allen. Ms. Allen, state your name for the record. Brianna Allen. Okay, appearances, counsel.
Austin Gregory, PA 5193, on behalf of Ms. Allen, who's present by Zoom, has been made aware of her constitutional rights. Waived from reading and after the court enter a not guilty plea on her behalf.
I'm sorry, the court will enter a not guilty plea on your client's behalf. Go ahead, Mr. Vincent.
I'm sorry, Your Honor, Steve Vincent.
Okay, one moment. All right, argument as to bond.
Thanks, Judge. Non-assaultive in matter. Previous charges all dismissed. Your Honor, we're looking at a malicious destruction of property, Judge. The people in this particular matter aren't going to object to the personal bond if this court so inclined to issue one. We would be asking for no contact where the incident took place.
Okay. Mr. Gregory, any objection?
A slight one, Your Honor, just that Miss Allen does say with the complaint is in their 10-year-old daughter. This is also a case that the allegation is a year old.
Actually, 2 years.
2 years old. So I would ask that she does be allowed. Okay. We don't actually have the investigative report currently, Your Honor. So,
are you saying the complaining witness and Miss Allen stay on the Baldwin address? Stay together?
no, you won't. Your Honor, very briefly now. Can we approach?
Sure.
It's just.
Yes. Yes, you may.
I'll come back to class later.
Okay.
Your Honor, we just asked for a no officer contact.
Okay.
People have no problem with that.
All right, one moment. And there's no reason for Ms. Allen to go to the Baldwin address. Is that correct? You don't know you live there?
That's correct.
Okay. Okay, the court's going to adopt the recommendation of the people and defense counsel. I'm going to give you, the court's going to give you a $5,000 personal bond. As condition of your bond, you're not to have any assaultive contact with the complainant, and you're not to enter or have any contact with the 2000 block on Baldwin Street in Detroit.
Okay.
You understand that?
Yes.
All right, your next court date is in front of Judge Bryant, August 25th. Pre-trial in front of Judge Bryant.
August 25th?
Yes, I believe that's at 8:30 a.m. You have any questions? I'm sorry?
Can I say something?
I didn't understand you.
My advice is, Ms. Allen, I would advise you to, unless you have a question about bond or your court date, I would advise you to not speak at this time. You do not need to argue, but no point in arguing.
Okay, anything else from counsel?
No.
All right, thank you. Okay. Yes.
We'll see you this afternoon. Okay, we'll see you this afternoon.
You're scheduled.
You don't think.
Hold on.
Hold on.
Let's turn our stuff on.